If you would like earlier access to my videos, please consider subscribing to my Patreon. Property. Historically, property has most often referred to a person's ownership over physical objects. Your house, your tools, your water and food belong to you and are for your exclusive consumption or use. This concept of property emerged as a result of the innate scarcity of physical objects. A house can only shelter so many people, tools can only be worked by one person at a time, and food which is consumed by one cannot be consumed by another. But what about ideas? The contents of a book, the likeness of a beloved character, the process by which a commodity is made. There is nothing scarce about an idea. It can be reproduced endlessly without ever being exhausted. And yet, today the term intellectual property is something we are all familiar with, the concept of an idea belonging to someone and being for their exclusive use. But why should the use of an infinite resource be made artificially scarce? I'd like to note here that the term intellectual property itself is a recent development. It only appears once in U.S. court records prior to the 20th century. Even afterwards, the term only entered widespread use in the second half of the 20th century. But the development of our modern understanding of intellectual property goes back centuries. Our story begins with a familiar concept. Monopoly. Even centuries ago, monopolies had long existed in Europe. For example, there was a system wherein state-sanctioned guilds were granted the exclusive rights to produce particular goods, armor or dyed clothing, or blown glass or locks. That is to say, under this system, the production of certain goods or services without the permission of the guild was prescribed by law. But European rulers granted monopoly privileges to individuals as well. In 1331, the English crown granted privileges to John Kempe, which is perhaps the earliest known instance of a royal grant of patent-like privileges to a group of foreigners. Rulers throughout Europe increasingly granted these kinds of monopoly privileges to encourage foreigners to move to their countries and produce desirable goods such as woven cloth or glass or printed books. In the process, these foreigners trained residents of the host country in their craft. In return, until the monopoly expired after a number of years, the production of these goods without the permission of the monopoly holder was illegal. A major milestone in the history of intellectual property was reached in 1421, when a patent of invention was granted to Filippo Brunelleschi for a new design of ship. This privilege, granted by the government of Florence in Italy, is commonly referred to as the first patent of invention in history. The first formal law on patents was passed 50 years later, in 1474 in Venice. It reads in part that, "By authority of this council, each person who will make in this city any new and ingenious contrivance, not made heretofore in our dominion, as soon as it is reduced to perfection, so that it can be used and exercised, shall give notice of the same to the office of our provisioners of community, it being forbidden to any other in any territory in place of ours, to make any other contrivance in the form and resemblance thereof, without the consent and license of the author up to 10 years. As we can see from the text of the Venetian law, these early monopolies were not granted as a reward to someone for inventing a particular kind of craft. Rather, these letters patent were given to whoever first introduced a particular process of production to the host country's jurisdiction, whether they were the original inventor or not. This is a demonstration of one of the most powerful arguments used to justify patents historically. We can call this justification an argument for social usefulness. These patents and patent-like privileges were granted because they attracted new inventions and crafts to the country in question. It's easy to see what the practical benefits of such a policy were. Venice was the first to formalize patents in law, but the idea would spread out across the continent. While these monopoly patents were generally meant to benefit the state by attracting new technologies from foreign countries, They were frequently abused by the royal administrations which issued them. Take England as an example. From around the year 1550, the English crown began to issue monopolies by means of letters patent, which is the origin of today's nomenclature. Under the reign of Elizabeth I of England, for example, monopolies were frequently issued to favorites. These corrupt monopolies ignited a debate that drew the legitimacy of patents into question. One particularly famous example of a corrupt monopoly was a letter patent for producing, importing, and selling playing cards granted to one Edward Darcy by Queen Elizabeth in 1598. Needless to say, playing cards had been manufactured in England prior to Darcy. This monopoly would be taken to court in 1602 by a would-be competitor. The Attorney General, Edward Coke, who argued in favor of Darcy's monopoly during the case, would later write a report critical of Darcy, calling his privileges an odious monopoly, and against the common law. He laid out 7 circumstances, all of which must be satisfied for a patent to be valid. 1. The term of patent must not exceed 14 years. 2. The patent must be granted to the first entry inventor, which truly meant first to introduce into English territory. 3. It must be of such manufacturers which any other at the making of such letters patent did not use. 4. It must not be contrary to law. 5. It must not be mischievous to the state by raising the prices of commodities at home. 6. It must not hurt trade. And 7. It must not be generally inconvenient. This kind of debate formed the environment in which the English Parliament formalized their patent law with the Statute of Monopolies of 1624. It was the first modern patent law in history, and it provided strict parameters by which monopolies could be issued. These parameters held a great deal of overlap with Coke's listed circumstances. To summarize, what we see laid out here in the 17th century, some 400 years ago, is a very different concept of intellectual property rights than what we have today. First of all, these monopolies were not property. They were not, generally speaking, transferable to other people. Nor would the violation of a patent be characterized as theft. They were considered a privilege that should be subject to conditions, in particular how useful they were to the society that granted them, rather than a natural right which should exist regardless of circumstance. A right, after all, cannot be discarded simply because it is generally inconvenient. The Statute on Monopolies had outlawed many monopolies within England, but some guild monopolies continued. The English Stationers' Company, a guild which held a monopoly on the printing of books, continued on as an exception under a law known as the Licensing Act. But that law lapsed in 1694, and during the next 15 years the market would be flooded with cheap editions of books from smaller printers. The result was the Act of Anne in 1709, the first formal copyright statute. The Act, a response to the demands of printers to protect their industries from counterfeiters, granted authors exclusive printing rights to their books. This Act attempted to restore some protections to publishers of books. But what is of particular interest to us are the reasons the Act of Anne explicitly gave for granting such protections. The first words of the law read as such: "Whereas printers, booksellers, and other persons have of late frequently taken the liberty of printing, reprinting, and publishing, or causing to be printed, reprinted, and published, books and other writings without the consent of the authors or proprietors of such books and writings, to their very great detriment, and too often to the ruin of them and their families, for preventing therefore such practices for the future, and for the encouragement of learned men to compose and write useful books." Here we see, alongside the much older argument that such monopolies are socially useful, a clear appeal to the moral rights of the author to their own work. These arguments dovetailed nicely with the writings of John Locke, the natural rights philosopher. Locke's theory of property rights was based on the idea that one was entitled to the ownership of the fruits of one's own labor. To quote one critical passage from his second treatise, "Every man has a property in his own person. This nobody has any right to but himself. The labor of his body and the work of his hands, we may say, are properly his." The text of the Act of Anne thus provides us with an important milestone in the history of intellectual property, because it marks a time when monopoly protections were increasingly argued on the basis of morality rather than simply social usefulness. The actors making these arguments from natural rights were powerful economic interests. In the case of the Act of Anne, these interests were private book publishers, who wished to coordinate with authors to win the rights to publish books without being subject to ruinous competition from other publishers. Interestingly, at around the same time in Lyons, France, a statute was passed in 1711 regulating silk manufacture designs under the guild system. It reads in part, "All master merchants, working masters, journeymen, and others employed in the manufacture of fabrics of silk, regardless of sex and age, are expressly prohibited and enjoined from taking, stealing, selling, lending, transferring, and using directly or indirectly any designs which have been entrusted to them for manufacturing purposes." Here we can see references to stealing, selling, lending, and transferring an incorporeal design. As scholar of intellectual property Frank D. Prager remarks, this phrasing was entirely new to the legal arsenal of the time. Here, it was clearly implied that such designs have a property character. This again was connected with the needs of powerful economic interests, in this case competing master merchants under France's feudal guild system. It was by the petition of these economic interests that designs took on the characteristics of property. The statute was amended several times in 1737, 1739, 1744, and 1787. The latter amendment would expressly refer to such designs as property. Meanwhile, from about 1750 onward, the spread of natural rights philosophy, combined with the growing understanding of technology as resulting from the intellectual labor of individual inventors, ensured that the Lockean concept of natural rights would be used more and more in arguments over intellectual property. For example, Adam Smith would argue in his famed Wealth of Nations that monopolies in the form of copyrights or patents were the easiest and most natural way in which the state can recompense companies for hazarding a dangerous and expensive experiment of which the public is afterwards to reap the benefit. This concept of intellectual property being rooted in natural rights would not confine itself to England. In 1790, in the wake of the French Revolution, the National Assembly declared, "It would be a violation of the rights of man not to regard an industrial discovery as property of its author." This was a reference to the works of Thomas Paine, another natural rights philosopher. France passed its first law on patents in 1791. The United States, itself a new government on the world stage, passed its first patent law in 1790. This philosophical framework, now entering into law in multiple nations, would be seized upon by an ascendant capitalist class, which sought to turn invention into property, in order to use that property as a vehicle of investment by which they could make returns and increase their own wealth. That same section of the capitalist class pushed for the internationalization of such laws, as up until this point patents filed in one country had no effect in another. What would follow was a decades-long effort to internationalize these new concepts of intellectual property rights. For the powerful economic interests in leading countries, whose ability to earn large and consistent profits depended on the control of particular technologies and ideas, the use of their intellectual property in other countries without recompense was the same as theft. But for the economic interests within the follower countries, who had little intellectual property of their own, such rights were nothing more than an odious monopoly that served to hamper their own ambitions of economic growth. It is no surprise then that the drive to universalize the rights of patent-rich capitalists met tenacious resistance throughout the 19th century. Spain's first patent law was imposed on it after the 1811 invasion by Napoleonic France, but it remained after the French left. Over the course of the 19th century, Spain took a stance that was common among the follower countries. It was incredibly strict in what it granted intellectual property rights to, and when it did grant such rights, it limited the time they were allowed to exist. Between 1826 and 1907, 75% of registered inventions lost their monopoly rights within 3 years and were transferred to the public domain. In the Netherlands as well, Dutch enterprises lobbied the government to abolish their own patent law, under which the majority of patented inventions were foreign. This resulted in the abolition of their patent system altogether in 1869. It would not be reinstated until 1912, under pressure from its neighbors. The Swiss, as well, had no patent law between 1850 and 1907. The United States passed patent laws in 1790, and 1793, but these laws only protected inventions by American citizens. As a result, businesses in the US, like in the Netherlands or Switzerland, were able to disregard entirely the supposed intellectual property rights of the more established countries like Britain and France. In 1836, foreigners were allowed to finally register their inventions in the US, but they faced higher fees and other forms of discrimination, and foreign copyright still wasn't recognized, allowing American publishers to sell copyrighted British books at a pittance. Philadelphia publishing house Sherman & Johnson would boast in 1842 that, "All the riches of English literature are ours. English authorship comes to us free as the vital air, untaxed, unhindered, even by the necessity of translation, into the country. And the question is, shall we tax it and thus impose a barrier to the circulation of intellectual and moral light? Shall we build a dam to obstruct the flow of rivers of knowledge?" One can hardly imagine a similar statement being made by a publishing house in the United States today. That is because the US today is perhaps the strongest proponent of intellectual property rights. And my purpose in sharing this extended history of intellectual property with you is so that you will understand exactly why. Governments both in history and today do not act in a vacuum. They do not articulate moral principles and codify them as laws separate from the social and material conditions that surround them. American book publishers of the past could take such glee in counterfeiting English books because even if England responded in kind and counterfeited American books, the American publishers would still come out on top. Thus, there was an economic incentive to ignore English copyright and to not view it as theft, but as something more noble, the proliferation of knowledge. Despite this history, the American enterprises of today, which hold a massive portfolio of intellectual property, will argue just as vehemently that similar counterfeiting is theft. This is because their economic interests have changed over the last 200 years. Stepping back from this long historical view of intellectual property, we can see that the current, which runs from 15th century Venice to today, is one of competing actors looking to secure their economic interests through appeals to morality. When Edward Darcy's monopoly on playing cards was labeled an odious monopoly by Coke in the 17th century, it was because of the friction it caused with other producers of playing cards. When the Act of Anne was passed in the 18th century, it too was a response to the economic interests of publishing houses in England. When the French government labeled silk textile designs as property, it did so in response to the needs of silk weaving guild masters in Lyons. And prior to the establishment of international treaties to govern intellectual property, there was a war of ideas between leader and follower nations, both sides responding to powerful economic interests within their own countries. The moral arguments for and against monopoly have always been deeply enmeshed in the economic interests that seek to create or destroy it. Ultimately, those who argued in favor of intellectual property would win the argument. In 1883, the Paris Convention for the Protection of Industrial Property was passed, followed by the 1886 Berne Convention for the Protection of Literary and Artistic Works. Although the US was not an original signatory to the Berne Convention, these treaties internationalized intellectual property rights between their members and represented a tremendous victory for the holders of monopoly. From this point forward, the word monopoly itself would start to disappear from mainstream discussion of patents and copyrights. Instead, it would simply be understood under the framework of property rights. That's it for this video. If you feel unsatisfied that we are leaving things at the end of the 19th century, then don't worry, there is still more to come. In the next video, we will be exploring the technology gap between the North and the South, and how it developed in the era of colonialism. I think this video will explain a lot about how our modern world came to be the way it is. Until then, thank you for watching, and be sure to subscribe to my channel. And if you'd like early access to my videos, or if you want to support my efforts, please subscribe to my Patreon.